Good afternoon, everybody, and welcome to today's iteration of the live employment law Q&A. My name is Teilen Celentano, and I'm an associate with Samfiru, Tumarkin LLP, and I work out of the Toronto office in Ontario. Before we get into anything, Khalid, it says you mentioned that you have some questions about long-term disability. I myself, an employment lawyer, so the focus of today's Q&A will be about employment law. We will have a LTD show within the next week or two, so it'd be best to hold on to your questions and ask them. Alternatively, you can reach out to us at our website. Our website is STS as in Sam, T as in Tom, lawyers.ca, and you can get in contact with one of our LTD lawyers that way. Today I'll be answering any questions you have, again, related to employment law live. So feel free to ask them, whether through YouTube, Facebook, X, Twitter, or you can go to our website at employmentlawyer.ca or shoot us an email at help@employmentlawyer.ca. I'd like to start out today by talking about the news that broke earlier this week about Edmonton City Councillor Jennifer Rice. She was accused of bullying and harassing a number of her subordinates in the workplace. Bullying and harassment is a very contentious issue and is unfortunately something we see quite a bit. Whenever a boss is treating you unfairly and it has risen to the level of bullying and harassment, in Ontario, there are two potential pieces of legislation that can protect you. The first is the Ontario Human Rights Code. So the Ontario Human Rights Code protects employees from being discriminated against on a number of enumerated grounds. Those grounds include gender, race, gender expression, sexual expression, as well as religion. So if an employer is bullying you, is harassing you, is treating you poorly as a result of any of those protected grounds, they are violating the Human Rights Code, and you can pursue either a lawsuit or a complaint against the company under the Human Rights Tribunal to have your rights protected. Additionally, employees are protected against bullying and harassment under the Occupational Health and Safety Act. The Occupational Health and Safety Act explicitly prohibits bullying and harassment in the workplace. And once again, if you are being bullied, you can file a complaint through the Ministry of Labor, or you can start a lawsuit. The shape of that lawsuit, whether through under the Human Rights Code or under the Occupational Health and Safety Act, will likely take the form of a constructive dismissal suit. Constructive dismissal suits are something we talk about pretty much every week here on the live employment law Q&A, and they occur when an employer is showing that they no longer intend to be bound by the terms of the contract, meaning they no longer are treating you the way they're supposed to. If you're being bullied and harassed and it has escalated to a point where you can no longer continue working in that workplace, a work environment can become poisoned and toxic, and you can pursue a constructive dismissal on those grounds. Well, these cases are highly specific and depend largely on the facts of individual cases, and always comes down to whether or not there's something in writing, something that we can point to that can prove it. It is very likely that if it has risen to the point where you don't think you continue working in the environment and it's no longer good for your mental or physical health, then it would be a constructive dismissal. So if you're in such a situation where you feel that you're getting bullied or harassed at work, before taking any action, reach out to us at employmentlawyer.ca. And one of our lawyers will be able to walk you through everything that's happened and kind of point you in the right direction in terms of what's next. Anna on Facebook asks, what are the rules about vacation? My employer advised that we were allowed to carry any unused vacation up to 5 days into the next year with manager approval when I joined. I wanted to take a few days over and inquired a few weeks back. And my manager said, why? We prefer it would be taken before the end of the year. Does she have the right to ask why? So Anna, she can't ask why, but she can't prohibit you from doing it. So under the Employment Standards Act, employees are minimally entitled to 2 weeks paid vacation during their first 5 years of employment and 3 weeks paid vacation after an employee has 5 years of tenure. The employees can carry that vacation forward for up to 10 months. So the vacation needs to be used within 10 months of it being accrued. So I don't know how many vacation days, but by the sounds of things, they're letting you carry over 5 days. it sounds like they're in compliance with their minimum obligations, they're allowed to ask why. You don't have to answer them, but you are entitled to carry forward those 5 days. So I think it's just something that, in a case like yours, Anna, just best to work collaboratively with your employer and try and get things figured out as best as possible. X on YouTube asks, can a nonprofit employer force staff to work at a fundraising event without pay or time off after working a full 35-hour week? So X, it depends a lot on the terms of your employment, whether or not you're an hourly employee or whether or not you're a salaried employee. Also depends on whether or not you're management. But generally speaking, no. Whether an employer is a nonprofit or a for-profit or a government entity for that matter, they can't make you work without pay, right? Now, that being said, if attending fundraisers is part of your regular duties of employment, and it's one of the things that you are expected to do in your job and it's enumerated in the contract, then yes, they can ask that you attend it. The overtime provisions of the Ontario Employment Standards Act only kick in at 44 hours a week. So if you're, as an example, a salary employee who works on average, Monday to Friday, 9 to 5 with a 1 hour unpaid lunch, making 35 hours, and then they ask you to attend an extra fundraiser after hours, and it's only for a few hours, you're not hitting those 44 hours a week. By rule, you technically wouldn't be entitled to any additional overtime. If this is something new, right? So if this is something that is new to your job, that was never contemplated before, that you haven't done in the past, and they're now asking you to attend these fundraisers, you can say no. And if they do choose to discipline you, that would be wrong, and you would be able to pursue some type of lawsuit, whether it's for a wrongful dismissal or constructive dismissal. But generally speaking, if you're a salaried employee and you're asked to work a little longer, but still less than 44 hours a week, you're not entitled to any additional compensation. Jack asks, I was let go from my position as a director after almost 20 years. I'm almost 60. I was offered the basic 2 weeks along with vacation. Upon accepting, I would be given an additional 4 weeks. This seems incredibly low. What should I do here? Jack, that's not only is that incredibly low, that offer's illegal. So again, I don't know whether you're not what industry you work in or what your job was specifically, but if you are an employee in Ontario and you're provincially regulated, irrespective of the size of the company, when you're let go, the company must give you either 8 weeks working notice or 8 weeks pay in lieu of notice as a bare minimum. And if they're not doing that, they're only giving you 2 and an additional 4 if you sign a release, then they are not only is the offer light, not only is the offer insufficient, it's illegal. So Jack, it's imperative that you give us a call, that you reach out to us at employmentlawyer.ca or email us at help@employmentlawyer.ca. Well, I obviously don't know the specifics of your job, Jack. Someone who with 20 years experience, who's 60 years old, especially a director, a severance package you would be entitled to at court is likely in the range of 20 to 24 months. So it's imperative that you do not sign anything, that you do not take the offer, that you in no way convey to the employer that you want to accept this, and that you instead give us a call and one of our lawyers will be able to help you out and get you significantly more than is currently on the table. Frank P asks, I'm on sick leave for 2 months. Do I need to contact my employer during this period? What happens if I don't call until 1 week before the end of the period to provide an update? So Frank, depends on how long you were supposed to be on leave. If you provided them a doctor's note that said, I will be on leave, or a doctor's note that said Frank will be on leave for 2 months, then the company should be expecting your return. Maybe reaching out to them a little more than 1 week in advance just to organize your return might be a good idea. This is especially true if you'll need to be accommodated anyway. So when you're coming back, maybe you need modified hours or modified duties or a gradual return to work where you start working 4 hours a day, then 6, then you're up to the full 8 thereafter. So you don't by rule have to. If the company is reaching out to you, you do need to respond. You do need to collaborate with them. But I think in a case like yours, Frank, and with anybody who's coming back from a sick leave, reaching out a little more than 1 week in advance, 2-3 weeks to organize your return, making sure the start date is hammered down, as well as organizing any potential accommodation in the workplace. I think it's a good idea to reach out a little more than 1 week in advance. Khalid asks, can I sue the company as I get discriminated at work from employee, and my boss doesn't do anything about it except talking to the employee, but nothing changes, and I'm now sick over a year. So Khalid, it depends on whether or not you're in the workplace, right? So if you're in the workplace and the company isn't stepping in to protect you, and all they're doing is, having unsuccessful conversations with your colleague who's harassing you, then you can pursue a toxic work environment. Employers not only have the obligation not to bully themselves, but they also have the obligation to ensure that the work environment is safe and tolerable for all employees. So a failure to act, a failure to take proper disciplinary measures can also be grounds for constructive dismissal on the basis of a toxic and poisoned work environment. But in your case, it sounds like you're not at work. So if you're not at work right now, it's difficult. It would be difficult for constructive dismissal suit to be successful. Now, if you're scared to enter the workplace because of this harassment, and your physician is medically supporting you not returning, as it would be detrimental to your physical and/or mental health, then it's possible. I think it's best, again, in Khalid, in a situation like yours, in conjunction with the LTD issues you mentioned earlier this morning, earlier this afternoon, I think it would be best for you to reach out to us at stlawyers.ca, where one of our experienced lawyers will be able to help you out and really get a full grasp on your situation. Frank P. as a follow-up says, if I'm on a 2-week sick leave and my employer is reaching out, but I am not responding, what are the potential consequences? Well, Frank, like I said earlier, it is best to follow up with them and to reach out. The company, you have an obligation to participate in the accommodation process. All employees do. And part of that accommodation process can be a sick leave, and it could be your return to work. So I think it would be best for you to respond to the company if they're reaching out to you. While it's unlikely the company may advance an argument that you've abandoned your employment, I don't think that argument would be successful, but I also don't think dealing with that argument and dealing with a potential lawsuit, would be best in your situation, provided the emails aren't incessant and provided they aren't rising to the level of harassment. They're just simply asking for an update. When do you think you'll be ready to come back? Is your plan still to come back after the 2 months? Then you should be, speaking with them. You should be answering them to cooperate with to accommodate, to assist them in accommodating you. Nick Patel on YouTube asks, as an employee of an engineering service provider, if someone outside work approaches me looking for services, do I have to bring them to my current employer if nothing written in employment agreement? So Nick, it depends on what exactly they're asking for. If they're approaching you in your capacity as a employee for this company, then it's likely that you would need to bring it to the attention of your employer. Whereas if they're approaching you in your personal capacity as a friend, as a mutual connection outside of work, then you wouldn't. One of the things I would be always caution people on is if they are taking moonlighting jobs, there's always a potential for a conflict of interest. Right? If you're providing services that the company could provide, that may be a conflict. And while it may not rise to the level of cause, and if you were terminated, you would still be entitled to a severance package, it would still likely result in your termination without cause. So it's a difficult position for you, Nick. Again, without reading your specific contract, I'm hesitant to say you're good to do it, you're not good to do it. So in a situation like yours, it would probably be best to have one of our lawyers review your contract with you to really explain what your rights are and what the contract means. There are oftentimes little terms that are hidden in, or some clauses that are much more expansive than they initially appear. And one of our lawyers will be able to help you review that and really identify what is what. In order to get in contact with us, again, you go to our website at employmentlawyer.ca. Amy asks, I have a close relative who was recently terminated. My question is, if they negotiated via email, receiving something additional to what was contained in their original release, and have received the employer's agreement in writing, is it required to receive and sign an amended release by the same original release deadline? In other words, can the employer hold my relative to the original release date? So Amy, the release date, I'm not sure exactly what you mean by that, if it's just the date on which they have to sign the release. If the improved severance package has been negotiated, then the date on which the release is signed largely becomes immaterial. If, however, the date past that, so meaning they said you had to sign the release by November 30th, and it was only today, December 1st, on which you actually agreed to the improved severance package, then saying you had to sign it by November 30th is obviously unreasonable. I think if you can provide me a little more clarification on what you mean by release date, I can hopefully help you out and be a little more specific. But generally, if an employer is imposing a date, they can enforce that deadline and can't technically pull that offer beforehand. However, largely, if you're, as long as you're returning the release pretty close to the requested date, companies will typically honor the severance package. Ray on Facebook asks, I work for a big company in Canada. It was sold about a year ago and was told pay and benefit would remain the same. After 1 year, they are trying to reduce benefits. Not sure what to do. Not sure what to do as everybody in the store is upset. Nobody wants to lose their job, but benefits now are poor. How much are they able to reduce benefits? So Ray, it's always a contextual analysis. So in your case, receiving benefits, right? The receipt of health insurance, life insurance, LTD insurance, accidental death and dismemberment insurance, all of that was a term of your contract. The company is allowed to make small changes to the benefits plan, right? So they can change from one insurance provider to the other, and they can, make small alterations. That's especially true if there's a term in your contract that allows them to make those changes. Whether or not such a change will result in a constructive dismissal always depends on the individual terms of an employee's contract. So it depends, and it also depends on the financial impact of that change, right? So the courts want to focus on real tangible change to your life. So if this change is just in theory worse, but doesn't actually result in less things being covered, then it could be difficult to pursue a constructive dismissal. So in your case, a change in benefits can be a constructive dismissal and can entitle you to a settlement package. So I'd recommend that you reach out to one of our lawyers at employmentlawyer.ca and provide us with both your past benefits package and then your new one. And then we can look through both documents and hopefully provide you with some clarity and advise on whether or not this change is enough to be a constructive dismissal. Nick Patel, as a follow-up, says if a job offer says an employee will have to bring any potential clients to the employer, can the employee ask to rewrite the job offer to include some commission for employee for bringing in new clients? Nick, you can negotiate anything you want into a contract, right? So if you're given a new job offer and you want to negotiate it to increase, to provide for commissions, even though you're not in a sales-focused role, that's absolutely something you can negotiate. It's something you can ask for. That said, it's not something the company has to do. So under the law, there's nothing that says a company has to pay you commissions, and there's nothing we'd be able to do to force them into doing it. With that being said, if you chose to ask and the company agreed, it's absolutely something that can be included. In Canada and Ontario, there's freedom of contract. So generally, as long as the contract itself isn't breaching any other laws, two parties can agree to almost anything in contract. So if they want to pay, if you ask for commissions, if you bring in your own clients and they agree to it, then yeah, that's absolutely something that could be included. Wayne Higby on YouTube asks, my company got taken over and then changed my job specification hours that I needed to work. I objected to this and emailed them that it was not acceptable due to my family balance. They said they will term. So if they choose to terminate you, then you are entitled to a severance package. How much you'd be entitled to depends on a number of things. But you may also be entitled to additional damages for your breaches of the Human Rights Code. So one of the things I mentioned earlier were quite a few enumerated grounds, but another one is family status. So your family status is protected by the Human Rights Code. Things like childcare and child supervision, or the need to pick up children from school, are things that have been recognized by the courts as being protected by the code. So if you explicitly said, I cannot change my hours because I have to take care of my family, because I have to take care of my kids, because I have to pick up my kids at school, because I have to be there for my spouse, for whatever, and they still choose to terminate you, that's a breach. That's a pretty clear breach of the human rights code. Now, if you just said, I want to have a better work-life balance and, my family's at home in the evening, so I don't want to work evenings, it's not that may be a little more difficult. But if, these change in hours they're proposing would prevent you from doing your familial duties, taking care of your family, then yes, it's a breach. Wayne, I think if they're going to terminate you, reach out to one of our lawyers. That's true whether or not you're offered a severance package. As a firm, we often see employees who are offered severance packages when they're let go that they think are fair, but are in reality grossly insufficient. So, Wayne, give us a call or reach out to us at employmentlawyer.ca, and one of our lawyers will be able to help you out. All right. So while we wait for a few more questions to come in, I'll shift gears a little bit and talk about some of the recent news stories we've seen related to employment law. So some of you may have seen TD has announced another round of layoffs, and that they're trying to reduce their headcount, which is obviously worried a lot of people who work for what I'm sure is one of Canada's bigger employers. So whenever an employee is let go, whether it's through mass layoffs or individual terminations, they're entitled to severance packages. And how much money they're entitled to doesn't, the maximum amount they're entitled to doesn't change. For TD Bank employees, they would be considered federally regulated employees. And while generally federally regulated employees can't be terminated without cause, if it's genuine bona fide restructuring, they can. So in the case of these TD employees, it does sound like it's bona fide restructuring, so they may not be able to pursue an unjust dismissal complaint, but they would still be entitled to a full severance package. Full severance package could be as much as 24 months, and how much it would actually be depends on a number of factors. Our courts look at factors like age, length of service, and availability of similar employment to try to ascertain how long they think it'll take someone to bridge the gap between the job that they are being terminated from and starting their next job. So there are cases where it has got traditionally the ceiling, the informal ceiling on how much severance someone could get was 24 months. But in recent cases, due to special factors, those ceilings have been increased to as much as 30 months. So if you are let go, whether it's an individual termination or it's a mass termination, reach out to us at employmentlawyer.ca, and one of our lawyers will be able to tell you what is a fair package in your case and how much, what your options are if the package is insufficient. Terrence on YouTube asks, can you be let go while on medical leave? I provided a note, but was told, but it was not clear enough and they need more information. So Terrence, if you do need a medical leave, you do have to provide them with medical information. The company doesn't have a right to know what your individual diagnosis is, but they do need to know what the prognosis is. So if the letter that you provided them was not clear enough for whatever reason, they are allowed to ask for more information. And that's especially true if you're on an ongoing medical leave. So maybe they initially they accommodated you by allowing you to start the medical leave, but now they're trying to see how long it will take for you to get back. So if they're asking for information, they're allowed to ask for updates. They're not allowed to harass you. So there is a line there where the request for updates can cross the line and become harassment. But if one of the letters wasn't clear enough, maybe the doctor's handwriting, I know doctors have notoriously terrible handwriting, wasn't clear and it couldn't be read, or it was just ambiguous as to much longer you needed to be off, they can ask for clarification. In an instance like that, you may ask the company to provide you with a form that can be filled out by your doctor. Something like a functional abilities form is oftentimes provided by employers and lists out a number of things that allow a company to ascertain whether or not you can currently return and what your limitations would be upon your return. So if it's just we're unsure, it wasn't clear enough, it was ambiguous, and they were just asking for more information about specifically your ability to currently work and when you may be able to return, they're allowed to do that. If they're asking for individual diagnoses, so what's wrong with Terrence? What was he diagnosed with? How is he being treated? they're not entitled to that private medical information. They're only entitled to the minimum information they need to know when you can work, whether you can work, and if you can work, how they need to support you in returning to work. Michael on Facebook asks, my wife works for a small dentist's office. They've informed her as they're a small family-run business, normal employment laws in Ontario don't apply to them, like severance. Is this true? So I think what they're referring to, Michael, is severance under the Employment Standards Act. So there's an employment law. There are a number of different terms that are used, and a lot of them are used interchangeably. So when I'm talking about severance, I'm talking at common law under the courts. But under the Employment Standards Act, which sits at the bare minimum entitlements people are entitled to, there's a distinction made between termination pay and severance pay. In order to be entitled to severance pay, which again is just a bare minimum, employers need to have a payroll in excess of $2.5 million, and an employee has to have been there for more than 5 years. That being said, the common law supersedes, overrides your minimum employment standards act entitlements if provided there's no contract that says otherwise. So, and it sounds like your wife works at a company that has a payroll under $2.5 million. So if she was let go, she may not be entitled to severance under the Employment Standards Act. That being said, she would still be entitled to severance under the common law. That's an important distinction to make. So in your case, or in your wife's case, I guess, Michael, if anything does happen and she is let go, she should absolutely reach out to us because, dentist offices are notorious for making mistakes when it comes to employment law. So, and with respect to the other stuff, so protections under the the Occupational Health and Safety Act, protections under the Human Rights Code, the vacation pay, the overtime requirements, those all still apply to your wife's employment. So if anything happens that she thinks is objectionable, she should absolutely reach out to us at employmentlawyer.ca. It looks like we have a spam person saying they accidentally stole an iPhone. Please don't interact with them. They are it's likely a fishing expedition. They're trying to get your information. So don't interact with young adizes. Okay, I've got enough time for one more question if anybody has one. Okay, last question for Tyler. Last question for today. Tyler on YouTube asks, how long can you be on leave for? So Tyler, I'm assuming you're referring to a medical leave. So how long someone could be on a medical leave depends. Depends on how long someone has been in a job for. Depends on how long someone has been on the leave. But what it really depends on, and what the big thing is, what is their prognosis for return? If there's a return in sight, meaning you expect to get better at some point, and a doctor is saying it may take Tyler a year, it may take him 18 months, but Tyler is going to get better, then the company is allowed to keep you on that leave for that long. If, however, something happens and as a result of a disability or a medical condition, you won't be able to ever return to work, then at that point, employees' employment would be considered frustrated. And in such a case, they would be entitled to only their minimums under the Employment Standards Act. So thank you, everyone, for joining. That's my time for today. I hope everyone enjoyed today's iteration of the live employment law Q&A. And if I didn't get to any of your questions, please save them up and join us at our next one. Hope everyone has a great Friday and a great weekend ahead. Thank you.